So I'm being sued by a company that I had never heard of until earlier in this year when all of this started. What's it over? These little tiny arrows. So in today's video, something a little different. Call it my defense that I hope is played and viewed by a court in Germany who are no doubt wondering why I'm not there in person to defend myself. The reason why I'm not there is because I shouldn't need to be over such a trivial matter. A lot of this video will be read off the screen for obvious reasons. I need to make sure I am true and correct, and we've got quite a lot of stuff to go through. So kicking off, today's story is an example of what happens when a trademark law firm goes rogue and starts to push around the little guy just a little bit too far. But it doesn't stop there. A company called Redbubble also find themselves in violation of my privacy rights and also have a case to answer. They've offered to pay the legal fees demanded by this IP lawyer uncontested, which sets a precedent that could be exploited by anybody against any creator on the Redbubble platform. This is quite the story. If you're here for the bike tech videos, I do apologize. This is not one of those. They will return in a couple of days, but this is something that I need to get off my plate. So some backstory on what I do and who I am if you're watching this for the very first time. I'm in Australia, if you can't tell from my accent. I'm not from New Zealand. It's really far away from the rest of the world. It really is. Trust me, long haul flights are a pain in the ass from this country. I don't follow European soccer or sports in Europe other than cycling. I wasn't familiar with the Hummel brand until April 23rd, 2021. I don't recall seeing their designs or logos on sportswear at all. If you were to show me this, I would associate that with the Kicker logo that I'm very familiar with. That's still what I see to this day. Now, as a business, I run a company called GPLama. I primarily cover cycling technology here online. My background is IT security and as a competitive cyclist. A few years ago, those two passions merged and I've created a successful business out of doing what I do today. If you have a power meter, a cycling head unit, an indoor trainer, if you use a number of the indoor software platforms online, it's highly likely they're a better product for the work that I do in front of the camera and some of it behind the camera too. That's a quick summary on what I do. Now onto my revenue streams. As a content creator on YouTube, I rely on views for that revenue. It's complex, but that's the summary. More views equals more money. That's why YouTube is full of clickbait. That's why Twitch is full of women and some men in hot tubs. Attention equals money, and good or bad attention, it doesn't matter. Views equals money, and this is why I'm uploading this YouTube video. It's going to pay the bills. As a content creator who usually delivers technical content that doesn't involve clickbait or hot tubs, sometimes it's a challenge to get views. I'll admit, some of the stuff that I cover is quite dry and boring. I find it interesting, but for the global community, not really so. Cycling is still a niche sport. At any time, YouTube could simply go away, so I need to diversify my revenue streams. Enter in merch. And finally, you say, Lama, you're getting to the point of where Redbubble come in on all of this. Let's kick it off. Redbubble.com. They're an Australian company that allows you to upload artwork and they'll print that on almost anything. T-shirts, posters, stickers, home decor. You upload one little tiny image, boom, they do the rest. They'll print it and ship it to you on anything. It's actually a pretty neat service. I've used it in the past. I don't think I'll be using it in the future, but it's one of the cheaper companies out there that does this. Onto the timeline that gets us to here. In July 2017, I put the Kicker chevron design on redbubble.com onto my profile. I just simply wanted a t-shirt with the Kicker logo. I was doing a lot of content on the Kicker, and I thought it would be identifiable as I present my videos. I put a personal order in for a t-shirt with this artwork. Actually, I've ordered 2 of these. Now, 4 years goes by. April 14th, 2021, the sale of 3 of those items goes through because as part of the artwork portfolio, anybody can order those items, but I wasn't really promoting that they were up there. So 3 of those t-shirts were sold out of Germany. I didn't know who to at the time. On April 23rd, 2021, I got a notification from Redbubble of the artwork being removed. Somebody had claimed ownership to that design, and following their procedure and policy, they took that down. I had 2 options there: to contest this ownership dispute or simply agree with it and case closed. Now, given I'd sold 6 t-shirts overall to that date and made $10.38, I chose not to dispute it. I wasn't aware of who Hummel were. I wasn't aware they trademarked the chevrons. I thought it was effectively open source or royalty free. It's just a pattern that I see everywhere. So I thought nothing more of it. On April 27th, I get a warning letter, 83 pages, from Boesling IP in Germany. I'll put a link to this full document with my personal details redacted, obviously, in the video description below. It's quite the waste of time to go through if you'd like to do that. Now, what they were claiming is ownership of this logo or design, which I didn't dispute at all. I'd complied with their cease and desist by immediately taking down the artwork and the case closed, but they wanted to continue to pursue me for their legal fees. Now, in this document is also communication with Redbubble, and here's where things get tricky. So I tried to log into my Redbubble account after receiving this, and my account was suspended without notice. So I raised a support ticket. On April 28th, I replied to Boesling IP with the following statements. Dr. Boesling, your conduct and communication on this matter is clearly legal harassment, something that I have little tolerance for. This reply is out of courtesy, and the time taken to write this will not be invoiced to your practice. Below are my statements on this matter. I was unaware of the existence of company Hummel Holding prior to April 23rd, 2021, when I received notice from Redbubble regarding the claimed ownership of the referenced chevron design. This design was influenced by the chevron patterns on the Wahoo Kicker indoor cycling fitness device. This is indicated by the work title, Wahoo Kicker Chevron, GPLama collection. There was no reference to Hummel Holding in any part of that artwork, either in name or hashtags for design search. This is a clear indication I was not attempting to trade on or with the Hummel Holding name or branding in any way. The chevron shape and design is used by many companies and road signs. To claim intellectual ownership of this particular pattern I had created is absurd. The direction, the shape, the spacing, the number of chevrons used differs to your client's usage of this shape. I've never seen Hummel Holding chevron design prior to April 23rd, 2021, so it's not possible I had copied or modified the logo in any way that your client would be able to seek compensation for. Following receipt of the email from Redbubble regarding the claimed ownership of the reference design on Friday, April 23rd, 2021, I did not agree with the claims. I did, however, choose to accept the notice and not file a counter notice on this dispute. In not contesting the dispute, I consider this matter resolved. As per the communication received from Redbubble on Friday, April 23rd, 2021, please note that in most circumstances, we will inform the complainant that you have provided a counter notice. As well, we provide the complainant with a copy of your counter notice, which will include your personal contact information. The complainant may then, if it wishes, take legal action against you. At the time of writing that email, that was in the terms of service of redbubble.com. They will not provide my personal details to the complainant unless I dispute the claim. I did not dispute the claim, I accepted it and moved on. Redbubble have overstepped the mark and violated my privacy right here in doing this. This opens up the whole can of worms, which results in this crap happening right here. So my reply continues. You state that your firm made a test purchase of the item in question. I was notified of the sale on April 14th. This was 9 days prior to you following the correct procedure to have a design dispute filed with Redbubble. This gives indication that your intent to extort funds from myself under the guise of a trademark dispute. Let me be very clear here. You do not follow the correct procedure with Redbubble to resolve this issue. I've had no further communication from Redbubble other than the initial dispute notice sent on Friday, April 23rd. If Redbubble have in fact provided you details as sent, this is a clear breach of my privacy, and they have not followed their own policy in regard to an intellectual ownership dispute. I did not contest the dispute, so under their policy, you cannot take legal action. It goes on. Redbubble appears to have since suspended my account without notice. I can only assume this is due to your actions. This is something that I have every right to file a counterclaim for. Furthering the embarrassment you've caused yourself, your firm, and your client over this matter, your test purchase of 3 items has doubled the total items ever ordered for this design on Redbubble from my creator's store. Should this information you've been provided by Redbubble be correct. So a total of 6 garments had been delivered. 2 of them were my own purchase, and a total of $10.38 in revenue had been made. This matter is over one single public purchase over 4 years. So in summary, the design in question is no longer available on Redbubble due to your actions in submitting an intellectual ownership dispute on Friday, April 23rd, 2021. Redbubble has suspended my account globally without notice, I assume due to your actions. You claim Redbubble has provided my personal and financial transaction details on a claim that I chose not to dispute. This was without notice or consent, which is a violation of my privacy rights. As per your provided communication, Redbubble have agreed to pay you the quoted fees of over €3,000 in goodwill. Unbelievably, they've offered this to you undisputed. This makes no sense in continuing to seek this fee from myself. At this point in time, I will refrain from highlighting these case details on any public-facing social media, which will no doubt cause reputational damage to all parties involved, including Redbubble for not providing any protection from a clear case of legal harassment of one of their creators. I consider this case closed. Any further communication on this matter, regardless of the content, will be considered an agreement that this case is closed. That was my reply, which they have acknowledged receipt of. So no strings pulled there, full transparency. That's exactly the reply that I put down there now. So from that, you can tell my intent wasn't to trade on their name. Let's continue. On May 4th, 2021, Redbubble replied to my support ticket asking why my account was terminated. Your appeal has been reviewed and we've determined that your account was wrongfully suspended. To make this right, your account has been reinstated. Oops. Now, between then and now, I was served with a... actually, I don't even know what this is. It's all in German. I believe it is a restraining order against me on a German court. I don't know. It's all in German. And today I was served with an international summons indicating that I did not agree to their cease and desist. I did. I just simply did not agree to their demanded fees that they just pulled out of their arse. This document that I've been served with today, again, links in the video description if you want to go through all of that. Again, my personal details have been redacted. If you would like those, just simply send Redbubble an email. They quite happily give those over. Easy. Okay, so reversing back onto the big warning letter that they sent. Look, it's 83 pages, as I've mentioned earlier on. It's quite the waste of time. In summary, they claim ownership of the chevrons in any direction and any number. That's fine. I don't care. I could agree to that, and effectively I have by not disputing the ownership claim on Redbubble. Now, the information provided by Redbubble to Boesling indicated that I'd sold 6 garments, 2 were for me, 3 were to Boesling, with a total commission of $10.38. There's a copy of the email from Redbubble Legal, James Toy in particular, included in this document here. There's a page or so of ass kissing saying why in a number of ways Redbubble are not liable. Finishing off with this paragraph right here, which, let's drop a few bombs. Against this background and as a sign of goodwill, please find the attached requested name and address of the seller responsible for the removed. So they've given my details, they've removed, so the cease and desist has been adhered to. Stop doing what you're doing. It's been stopped, as well as the respective sales. Further, Redbubble is, without prejudice, willing to pay the legal fees in the amount of €3,247.90 incurred by your client in connection with this complaint. Redbubble rolled over, undisputed, to this trademark lawyer. Let's just stop there. Goodwill. In goodwill. So Redbubble have thrown me under the bus, offered no protection by disclosing my personal details, which means that I'm now subject to these court proceedings. They've offered to pay the legal fees, so case closed. So there's a lot to unpack here. That's a problem, especially when I chose not to contest the claim. I followed policy and procedure on Redbubble to do the right thing. I accept that Hummel may own the trademark for this, and I simply wanted to click a button and have it go away. This is over $10. Now, given that Redbubble disclosed my personal details uncontested and offered to pay over €3,000 unquestioned, this should be a concern for every single holder of a Redbubble account. You could be liable for anything. If you put a circle or a square or a line, anything at all on Redbubble, a company can come along that you didn't know about, claim ownership of that, and then eventually you'll be sent to court to have to pay $250,000 or go to jail for 2 years. That is just absurd. That's a position I'm in today. So if you're after a quick buck, just simply send Redbubble an email with a letterhead and have yourselves a Merry Christmas on me. Now let's cut the shit and onto what I think has really occurred here. Boesling IP screwed up their estimation on the size of my trademark infringement. They spent days and days building the case on me prior to finding out it was only over 6 garments and $10. Again, they ordered half of those. They hit the jackpot when Redbubble disclosed to them my personal details, so now they had somebody to file some complaints against and attempt to recoup some costs on. The fact that I didn't dispute the artwork ownership on Redbubble just adds to their further embarrassment on this one. So from here, there really isn't much for me to do. I don't have the resources or money to defend this whatsoever, so there's nothing really much I can do, hence me making all of this public. The internet can be my defense. Go for your life and do whatever you need to do with it. I accepted the dispute on Redbubble on April 23rd, 2021. I didn't agree with it, but I agreed with the policy and the process as laid out, and I followed that to the T. And as you can clearly see, it's not worth me even trying to defend the ownership of that logo over $10.38 over 4 years. From here, Redbubble need to issue an apology to me on this on a few fronts. One, for disclosing my personal details. Two, for terminating my account for a period of time with no reason given. And three, for offering me zero protection against this trademark firm and what they're up to. I followed the terms of service on Redbubble. They did the wrong thing. Hummel and Dr. Boesling, well, they just simply need to admit their mistakes on overestimation and move on from this one. I respect the procedure they're following to protect their trademark they're responsible for. If my intent was to knowingly trade on their name, logo, etc., their actions would be justified. This was clearly a case of overestimation on their behalf that was resolved immediately upon notification that came through. It's my honest opinion that both Hummel and Boesling IP are an embarrassment to an otherwise well-respected and trusted profession of trademark law. All of this over $10.38 and an acceptance to remove the artwork. Should I have done my due diligence? That's a good question. It's a pattern that I see everywhere on kickers, on street signs, on other logos, on other sportswear that isn't Hummel. I'm not going to link to any of those and throw other people under the bus. That's up to Hummel to do, and send their own lawsuits to those people. I assumed the pattern and design was just simply royalty free. When I found out it wasn't and Hummel claimed ownership, I did not dispute that, and I still don't dispute that. I do dispute what they're trying to pull right here in this documentation. This is straight up bizarre. So, in summary, to explain like I'm five, Hummel, stop that. We own it. Me. Oh, okay, no worries, I wasn't aware. That stopped. Hummel, give me your lunch money. Me. Hummel, give me your fucking house. Me. Oh shit, this is going on YouTube now. And with that, I rest my case. We done? That's all right?
Yep.
Oh, let's jump. Oh shit.